Welcome to the latest Evershed Sutherland Legal Insights podcast.
Hello and welcome to the latest episode of the Labour Exchange. My name is Claire Ward and I'm joined by Leonie. Leonie, do you want to introduce yourself?
Yeah, thank you, Claire. Hi, everyone. I'm Leonie McQuaid, and today we are going to be discussing the latest developments relating to the Employment Rights Bill, the latest trade union statistics, and Claire and I are going to chat about what employers can be doing to prepare for the access provisions that are coming down the track. So, what do the latest stats look like, Claire?
Well, trade union membership is actually at an all-time low. So that means it's at the lowest rate since records began in 1995.
Wow, really?
Yeah, the proportion of UK employees, who were trade union members actually fell to 22% in 2024. So that's down from 22.4% in 2023. And so that means that's the lowest union membership rate on record since the ONS has been collecting data. So that's since 1995. In numerical values between 95 and 2024, the level of membership has fallen by 735,000. So overall, that's 10.3% or 7.1 million to 6.4 million.
And has that reduction been the same across both the public and the private sector?
No, the decline since 1995 has primarily occurred in the private sector. So membership amongst public sector employees has stayed relatively stable. So the density actually increased from 49.5% in 2023 to 49.9% in 2024, so a slight increase, whilst in the private sector it's decreased from 12.2% to 11.7%. So, Leonie, you and I previously discussed the blacklisting case on a previous episode of the Labour Exchange. So that's the Moray and Ryanair case. Is there any news on that front?
Yeah, sure. There definitely is some news, Claire. And would it be helpful if I first recapped about what that case is about?
Yeah, that's a really good idea, actually.
Okay, no problem. So in this case, the employer withdrew discretionary travel benefits from pilots for a period of 12 months after they participated in industrial action. The pilots argued that compiling the list to facilitate that withdrawal of benefits amounted to a prohibited blacklist under the blacklisting regulations. The Employment Tribunal and the Employment Appeal Tribunal did decide in favour of the pilots, finding that the production of the list by the employer to identify the individuals who had taken part in the strike action in order to withdraw the travel benefits did amount to blacklisting. The employer did appeal, but the appeal was dismissed by the Court of Appeal, upholding the decision of the lower courts. So in summary, the decision has interpreted the blacklisting regulations pretty widely, and it's also cemented the view that periods of industrial action are covered by the protection of the blacklisting regulations, which, as we've discussed previously, is different to the decision of Mercer in the Supreme Court, which decided that the protection of Section 146, which is the trade union detriment provisions, did not extend to periods of industrial action.
So what does that actually all mean in practice for employers?
Yeah, so it's a lot to think about, but essentially this means that employers should exercise caution when compiling lists of striking workers and consider if they are being compiled for a discriminatory purpose.
But is there going to be another appeal? Is this just the latest in a sort of a long line of developments?
No, so the very recent news and an update from our last podcast is that the Supreme Court has now refused the employer's application to appeal. If that is of interest, we do cover that case in more detail in our March update that's available on the website.
And the Employment Rights Bill that's coming along is bringing changes, though, in this area in relation to detriments and blacklisting, isn't it?
Yes, that's right, Claire. So the Employment Rights Bill is essentially trying to plug the gap created by the Supreme Court in the Mercer decision to ensure that there is protection against detriment for taking part in industrial action. In addition, there's also going to be a strengthening of the existing blacklisting regulations we've just spoken about. For example, extending the protection to workers, not just employees, and also liability for third-party acts. So, Claire, where are we up to on the timing of the Employment Rights Bill changes? As obviously keeping an eye on timings and implementation dates will be really important for employers.
Yeah, it certainly is. And this isn't a case of one implementation date. And we understand that the government is being pushed for a timetable, which will be really helpful for employers. The bill is moving towards royal assent, which means that it will become an act, and that is still looking likely to happen in July before Parliament has its recess and everyone goes off on their summer holidays. Progress has slowed slightly in recent weeks, but that is still our best estimate. We have discussed in detail the changes to collective employment law, all of which are significant, and they are in previous episodes of this podcast, which are available on our website. And those changes affect both unionised and non-unionised employers. I think a few employers have been thinking that this is something that one or the other need to be worried about, but actually all employers need to be abreast of these changes. And they're set out in our March update. And also available in our tracker, which is kept fully up to date. So is a really good thing to save on the desktop to save you looking for emails. And all of that sets out the various different timescales for implementation, as we're estimating at the moment.
Great, thank you, Claire. And the details, the finer details of all of these changes are not yet available, as we're obviously awaiting further consultations and implementing regulations. But there are some steps that employers should be considering now, aren't there, Claire, whilst we await this detail?
There certainly are, and our June labour law update, which is available now, covers the steps that employers could be taking as they prepare for the changes to collective consultation, fire and rehire, changes to statutory recognition, the industrial action amendments, and if that's not enough, there's also some changes to individual rights.
Quite a lot to think about, isn't there? We've been talking to a number of employers who are starting to realise that they need to prepare for access requests in particular, haven't we? Can you recap on what the new right of access entails?
Yeah, sure. So trade unions will have a new right to negotiate workplace access agreements, and this will include a right to digital access as well. And the idea is to allow officials to meet, support, represent, recruit, or organise workers, or to facilitate collective bargaining.
And there's a presumption in the bill, well, my understanding is that a union will be granted access in most cases.
Yeah, so it's not really a case of if, it's more about how and the method of that access. There'll be very limited circumstances where employers would be able to refuse access altogether, and that means that employers, both unionised and non-unionised, should be preparing now, probably starting with what's their philosophy, how do they want to approach this new right, and what's their strategy when requests are received. How will the organisation respond, and will that response be sort of consistent across the business, or will it be approached on a sort of a business unit or a site-by-site type basis?
Interesting. I was actually talking to a client this week who was really surprised that they needed to be thinking about this. They'd assumed that it wouldn't apply because they already had a recognised trade union in place. However, this is not just limited to areas of the workforce that don't already have recognition in place. And key things an employer needs to consider are: how will you approach requests where there's already a recognised union in place? Would it be helpful to talk to the existing unions to come up with a joint approach for dealing with requests from potentially competing unions? We don't know yet whether competing requests would factor into a request being unreasonable under the access provisions, but these are all things that clients need to start thinking about.
Yeah, and a client I was talking to said that they were really concerned about ensuring a consistency of approach. They commented that they weren't convinced that the managers on some sites might even recognise that they'd had a request for access. And our understanding is that the system that essentially be in place could be really rapid, a bit like the statutory recognition process. So if they make a request, there'll be a tight time limit to respond, and then an employer could find themselves in front of a CAC and in a formal process. And so they really need to ensure that HR and managers are trained and that they understand the organisation's approach, so they know what to do with that request, they know what the expectation is. And for most employers, we would expect that they would want to have a coordinated and consistent approach. And, some are starting to think about perhaps putting together model access agreements, so they're ready to respond to a request with what they think access ought to consist of.
Great, and just a reminder, this right of access is both a right to request in person and digital. So I think employers will also need to be looking at what digital communication tools are being used currently, and if there's a need to change the approach.
Yeah, and I think they also need to be auditing, how what their approach is to visitors already. Are they used to having third parties coming onto their premises? Is there a visitors protocol in place? And if so, does it reflect how they would want to treat visiting union representatives? And if there isn't one, should we draft one? Should we have something in place if this is not something that a site or a store is used to dealing with?
Yeah, and this isn't just a HR issue, is it? The organisations will need to engage with various different teams to look at what the key issues are arising from having third parties accessing a workplace.
You're absolutely right. I would have thought stakeholders from health and safety, security, data privacy, insurance will all have an interest in this evolving right. And for some organisations, there may even be regulatory requirements, perhaps attached to, the requirement to, keep certain things confidential or similar.
And it definitely feels to me that a health check of current employee relations would make sense to consider whether there are any sites or areas in the business that might be the first to receive a request or might be more susceptible to these new access rights.
Yeah, I completely agree, Leonie. I think that would be really useful starting point, together with all of the other things that we've said that's probably scared people enough for one podcast. So we'll draw it to a close there, and please do continue to follow our tracker for the latest news and timescales. And I thanks Leonie for joining me today.
Thanks everyone for listening.
Thank you for listening to the Evershed Sutherland Legal Insights podcast.